Senator Lyons.
Thank you, Mr Acting Deputy President. And I rise to oppose the Safety Rehabilitation Compensation Legislation Amendment Exit Arrangements Bill that's before us, and I can assure Senator Back that I absolutely 100% support workers getting their full entitlement to workers' compensation scheme, and to suggest that if you vote against the bill, somehow you're voting against the safety and the well-being of workers if they're injured is absolute rubbish. This, Mr Acting Deputy President, is one of 3 bills around workers' compensation which will disadvantage workers. This is bill number 2. And the Abbott government really does need to lay out its plan. We see bill number 1, although it hasn't come into the Senate, bill number 2, which is before us today, and of course there's a 3rd bill. And to suggest that somehow these bills are unrelated is not true either. That there are relationships between all of them, and it is clearly about disadvantaging workers. And if they're not related, then why have they been brought in together, and why are they all about Comcare? Of course they're related, and this bill is being put before the Senate because the government thinks perhaps it will get support for this bill and it will start the softening up process to get the other 2 bills in place. And indeed, we were able to have an inquiry for the first bill, and what stakeholders told us in that process is that, yes, they'd had meetings with the department, but they were bound by rules of confidentiality. So they weren't allowed to ask, they weren't allowed to speak outside of the meetings about the content of those meetings. And when they sought additional information about bills coming forward, they weren't told anything either. Now, what sort of consultation process is it when we bind people and we make them sign documents that they won't utter a word about what happened in the meeting, and when they sought information about future bills, they were told that wasn't part of the discussion? I mean, that is not an open and transparent process. And of course, those stakeholders had every right to be suspicious and to be very concerned about what was going to be coming next because of these confidentiality provisions. And in the inquiry we had on that first bill, we asked the department if we could have further information, but we were told no, we couldn't either. I think we ended up getting the attendance list of who attended those secret meetings, but we weren't able to get much further than that. So Labor opposes this bill, and fundamentally this bill will allow employers and insurers to scheme swap at will between state and national schemes. This arrangement laid out in this bill may potentially lead to the economic collapse of state schemes, and Labor believes it's likely to drive up premiums for small to medium-sized employers. Again, with this bill, the Senate Education and Employment Legislation Committee was denied a public hearing by majority government senators on the committee. And it's absolutely shameful that this open and transparent process was denied to us. It's the second time, Mr Acting Deputy Speaker, that I've reported in this place that on government-controlled inquiries, senators have been denied an open and public, transparent process. It is one thing to have submissions in front of you. It is quite another to have witnesses in front of you where they make particular statements that are worth exploring, or they give you further information than what was in their written submission. But no, the Abbott government and its senators in this place absolutely denied an open, public, transparent hearing into this bill. So it is left to Labor to defend and raise our concerns in this place about the bill, because we were denied that opportunity through the Senate processes. And more we're seeing that when the government doesn't want to be held accountable, when it doesn't want to listen to independent evidence and experts, it simply uses its numbers and denies the Labor senators that opportunity for an open and public hearing. So it does lead me to say, what are they hiding? What is it about this bill in particular that they don't want transparency to be on the record? And despite what we heard from government senators, there is no need to rush this bill. There is simply no need to rush this bill because despite the ACT signalling it wishes to exit the bill, they're a long way from doing that. The ACT government is in the process of consulting about the makeup of any new scheme. It does not yet have a designated scheme, and it won't for some time. So why the rush? Well, as we know, there's a bill that hasn't been voted on in this place that looks to cut workers' entitlements. And what I think the government is trying to do is to soften up the crossbench senators and get this bill through and then say to them, it's all a part of a tranche. There's 3 bills here. You voted for the first bill. The sky hasn't fallen down. Let's bring the other bills in. I'm sure that's their plan. But it is time that the Abbott government laid out their plan and stopped trying to pretend there was no link between any of these bills, because there is a link. So the ACT government is out there running an open and transparent process, unlike the opportunities to have an open and transparent public hearing in this place, which we were denied by government senators. So why the rush? And rather than try and push a bill through the Senate, why isn't the Abbott government talking to the ACT government? Why aren't they talking to them? Now, maybe they are, but again, we don't know because we didn't have that public hearing. But what we do know from the Abbott government's track record is they don't like to consult. They don't like open consultations. They don't like independent advice. They don't really like anything contrary to their own positions. So the Abbott government thinks the only way forward is to rush this bill through. And Labor wants to be absolutely certain that no worker will be worse off as a result of this bill. And Mr. Acting Deputy President, I speak from experience. I worked for quite some time as the Workers' Compensation Officer at the WA branch of United Voice. And in that role, one of the hardest roles I've ever done in my career, I met workers with debilitating injuries, low-paid workers, cleaners, orderlies, nurses, early childhood educators, manufacturing workers, many with debilitating injuries. And I met workers who desperately wanted to get back to work, who wanted to look after their families, to do all the things they did before they suffered a workplace injury. I worked with good employers who respected workers and did everything in their power to get workers back to work and to start the rehabilitation process. Unfortunately, and in the majority of cases, I also met employers and insurers whose agenda was to reduce their costs and to take no responsibility for injured workers. Sadly, I saw too many workers caught up in a situation not of their making and completely outside of their control. I saw deliberate actions taken by insurers and employers to drag out claims, to deny benefits, to put workers in a situation where they had no money coming in, to blame workers for the workplace injury, to suggest it was because a worker smoked or was not fit enough or was old, any excuse other than to take responsibility that their workplace had injured that worker. I saw workers treated disgracefully at the hands of employers and insurers. Workers who throughout their working life had given extra, who didn't knock off right at the end of a shift. Workers who always were willing to take on additional roles and gave loyal service, and who expected, in their time of need, their employer to act in the same way when they needed support. I've seen workers totally broken who started out with a physical injury and ended up with mental disabilities, not because of their injuries, but because of the way they were treated once they entered the workers' compensation scheme. And there were far too many of those who were broken individuals as a result of a workplace injury not of their own making. And as a Labor senator in this place, I stand for fairness and justice for these workers. And I want to touch on another point raised by Senator Back, which came out at the hearing we had on the first bill, and I must say I couldn't believe what I was hearing. I didn't want to believe the words on the page, where the first bill seeks to take away the right to workers' compensation during an unpaid work break, an unpaid lunch break. Let's just imagine the early childhood educator who started her shift at 7 and works in the city and has maybe travelled an hour to get to work, so she left home at 6. So maybe she's got up at 5 to start her day, who at lunchtime wants to have a break. And I don't know, Mr Acting Deputy President, whether you've been into a childcare centre, but unlike perhaps a big manufacturing workplace or a hospital or an aged care facility, the staff rooms are very small, and they often act as meeting rooms for other workers, or they often act as places where workers do programming. So they're not always the place to relax, to get away from the children, to have that desperately needed break. Because working with children is hard and rewarding work, but it's hard work. So the bill that's currently sitting in the Senate says if that worker walks over to the shopping centre, and let me tell you, Mr Acting Deputy President, that in my experience as an organiser in the early childhood sector, many workers like to get out and have that break. Many workers like to leave the centre at lunchtime. If that worker leaves the centre and trips or hurts herself under the bill before this Senate, she'll be out on her own. She'll be out on her own. Now, I can also tell you, Mr Acting Deputy President, that many of those workers work a day shift. And as you know, getting to the bank or the post office is often something workers do in their unpaid break, because it's the only time they can do those things. And I heard Senator Back say, oh, well, they'll be covered by, public liability, or they'll be covered by motor vehicle. Can you imagine the scenario? So there I am, leaving the childcare centre. I walk down the pavement and I trip. As a low-paid educator earning about $21, $22 an hour, well, I'm going to engage a lawyer to sue the council. How likely is that? It's incredibly unlikely, and it's impossible. I wouldn't know where an early childhood educator would get the funds to stump up money for a lawyer to sue the council and to win. We know those claims are arduous and they're hard to prove. So I'm walking across the road. I then make a claim on motor vehicle, do I? Or I finally get into the shopping centre and I trip over. Well, I then go after the shopping centre's public liability. What a ridiculous statement to make, that somehow someone else is responsible for that worker. The other thing I can inform the Senate is the break in childcare centres is an hour, not because the worker needs it, but because the employers like to stretch the day out so they don't have to bring additional staff in. So they have that worker there from 7 till 4 and they give them an hour off because they want to lengthen the shift to reduce their rosters so they don't have to bring other workers in. And here we're saying that that worker who leaves the childcare service at lunchtime to have a break or pay a bill or get to the post office is somehow on her own. What a ridiculous statement to make, and it just shows how absolutely out of touch this Abbott government is, that they don't understand what workers do during their lunch hour. And during the Senate inquiry, we heard about this ridiculous, Senator Abetz and the Abbott government are very good at just making things up. So they talked about the worker who goes surfing and incurs an injury. Well, I don't know how many workers Senator Abetz has met, but over my lifetime as a union official, I've met thousands, and I've never yet met one who went surfing during their lunch break. I've met plenty who went shopping, who bought the dinner, who went to the post office, who paid the bills, who rang their kids to check on how they were doing, and did all the things that all of us do as part of our daily life. But that is what you'll hear from those opposite. What about the person who goes surfing? Well, what about the early childhood educator who simply goes to pay a bill and somehow then gets denied workers' compensation because she's had an accident outside of the workplace? I mean, that is just ridiculous, and it is not something that Labor senators will support in this place. And I want to make it absolutely, and I want to be absolutely sure, whether it's this bill, Bill number 1, or whether it's this bill before us, number 2, or whether it's the incorrectly titled Bill number 3, improving the Comcare scheme, that no worker is worse off. And those assurances are not there. They are clearly not there with these bills. And nothing I've read, and nothing I've heard, and nothing as in my own experience as a workers' compensation officer and as an organiser gives me confidence that the bills deliver confidence and real surety and protection for workers. What I see in this bill continues the Abbott government's anti-worker and anti-union agenda. I counted the bills the other day because I got invited to speak at the National Mourning Day for workers killed on the job in Perth. Something like 15 anti-worker or anti-union bills that the Abbott government has brought before this place. Remember when we heard work choices was dead, buried and cremated? Well, it's not. The Abbott government is trying to attack workers and their unions by stealth through 15 bills, most of them rejected in this place. Most of them rejected in this place. And that is work choices, when you start to take away workers' rights, when you start to reduce their access to unions. And I've spoken before about the appalling death rate in the construction industry that goes completely unnoticed by the Abbott government. We should have a bill to immediately look at and stop workplace deaths. Not these sorts of bills which rip entitlements away from workers. It's a disgrace that we don't respect those who toil, that we don't respect lives, that we think it's somehow okay for someone to lose their life when earning their livelihood. Well, Labor senators don't stand for that, and that is why we oppose these bills. And the Abbott government has not undertaken proper consultation with all of the relevant stakeholders about this bill. Now, no doubt they'll tell us, well, we had secret confidential meetings that no one's allowed to tell you about. But they denied us a proper hearing where we could get evidence out in the open on this particular bill. And it is really important that there's a thorough investigation of the legislation, because the Abbott government has already sought to make adverse changes to the Comcare scheme. These proposed changes will directly and indirectly risk the workplace health and safety of Australian workers. And what we heard in the first hearing, and that's the only hearing I can refer to because we haven't had a hearing on this bill, was somehow we needed to make these changes to the Comcare scheme because of red tape. Well, I tell you what, if the choice for me and other Labor senators is red tape and workers' lives, red tape and workers remaining fit and well in the workplace, I'll pick red tape any day. And I know there's not a Labor senator here who would say, let's reduce red tape and create a risk that injures, or in the extreme example where a worker dies. No. There's somehow a view from the Abbott government that all red tape is somehow bad. Well, it isn't, because workers in this country need red tape to protect them. They absolutely need that. And so we won't be supporting words that say improving and simplifying, because we know that reduces workers' entitlement and puts them at risk. And so we won't be supporting this bill. Thank you.